Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're going into part 2 on trusts. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. In this part 2, in relation to trust, we're going to be dealing with what are some of the things that have to be inside a trust instrument. Now, please make sure to like, share, and subscribe. And make sure you ring the notification bell so that every time I put up a new video, you get notified. Now, a trust instrument, as I said in part 1, would be the agreement between one person to give away their property to someone else, and this one person being the founder and settler, and this someone else being a trustee for the benefit of another person being the beneficiary. Don't forget to watch part 1 if you haven't, in order to know who can be a founder or settler, a trustee, or a beneficiary. This trust instrument, like I said in part 1, before this Trust Property Control Act came into existence, could be in the form of a notarial deed. However, it wasn't always necessary. Even now, under this act, this written instrument doesn't necessarily have to be in the form of a notarial deed. If it was a notarial deed, or if it is a notarial deed, not only does it have to be registered with the Master of the High Court, but it also has to be registered with the Registrar of Deeds. However, if it's not a notarial deed, it only has to be registered with the Master of the High Court. Inside this trust instrument, there has to be an identification of who the founder or settler is, an identification of the donated property. You have to say who the initial trustees are and who the beneficiaries are. And remember from part 1, the beneficiary can be a specific person or a class of people. You have to then also identify the process of appointing other trustees going forward. So, for example, if inside the trust instrument you say the first trustees will be 3 people and you write down their details, and there will be trustees for a period of 2 years, you then have to say how the other trustees after those 2 years will be appointed. You also have to say, in the event one of the trustees passes away or they resign, how they can do it, how the new trustee will be appointed, and so on. You also have to set out in the trust instrument the objects of the trust, being what is it that the trust is created for? What do you want it to do? Is it a trust that will deal with inheritance of a specific person? Is it a trust that is created as for charitable purposes, and so on and so forth? You have to set it out so that it is clear from the reading of this trust instrument what the trust is created for. You also have to set out how the trust can be brought to an end or dissolved. And if the trust holds any property, what has to be done with that property? Is it going to be donated? Is it paid to a beneficiary? What is supposed to happen? And people have to understand that sometimes a trust comes to an end just simply because of its nature. For example, if the trust is created for the benefit of my grandchildren, and in it says at the age of the last one turning 25, then they will all be paid out from the trust money equally, then it means the trust will just come to an end because its objects have been met and the reason for its existence has passed. The trust instrument should also talk about how changes are made to it or amendments, as well as the rights and responsibilities of the trustees in that trust, and the manner in which the trust makes money, if it can make money. So, for example, some trusts might allow the trustees to have the power to invest money, but they might then decide trustees don't have the power to invest in high risk investments, for example. They can only invest in real estate and things like that. Whether the trustees have the power to borrow money and so on and so forth. So the trust instrument is effectively to try and put as much as you possibly can into setting out the powers of the trustee over and above those that are set out in the Trust Property Control Act. Because the Trust Property Control Act is a general framework for all trusts, but the trust instrument will be specific because of the nature of the trust that you're creating. It will also set out the issue of quorum of trustees to say, in order for trustees to be able to make a proper decision, there has to be a minimum of 3 trustees sitting in a meeting and so on. So those are the general things that need to be there in a trust instrument. But remember, it is always best to get a professional to help you prepare this trust instrument, because sometimes you might think that you need to create a trust for something, and then you might find in discussing this with a professional or an attorney that the thing you're actually looking to create is a society or an association, or simply to just say, no, create a will if it's an issue of inheritance. So it is always best, before you go down the road of registering a trust, to know whether or not a trust is the proper vehicle for what you want to do. Now, that being said, I hope you got something of use in this video, and I hope it has given you some insight in relation to what should be in the trust instrument. And I hope to see you in part 3, where I go into detail about the rights and responsibilities of trustees, so that you know, when you say I am becoming a trustee, you know the heavy burden that is put on your head. And I hope to see you in my next video. Bye!